I'm Noreen Ajmal. This vlog looks at the principle of accountability and the requirements for transparency under the GDPR, which comes into force in May. The data protection principles in Article 5 of the GDPR are not vastly different to the principles set out in the Data Protection Act, but what has changed is the addition of an accountability principle and a greater emphasis on transparency, which is likely to mean having to change current data protection policies and procedures. Article 5 of the GDPR states organisations must process personal data lawfully and fairly in a transparent manner, and that the controller must be able to demonstrate compliance with the data protection principles. This means being open and clear about how personal data is being processed and being able to evidence and show how you comply with the law. Organisations will have to be transparent in the information they provide individuals through a privacy notice or otherwise. The information they supply about processing of personal data will need to be concise, transparent, intelligible, and easily accessible, written in clear and plain language, particularly for children, and be free of charge. The ICO's guidance on GDPR helpfully sets out a table of information that organisations should supply individuals and at what stage. The information to be supplied depends on whether or not the personal data was obtained directly from the individual. On the accountability principle, the guidance explains that organisations will be expected to put in place comprehensive but proportionate governance measures to demonstrate compliance. These may include implementing appropriate technical and organisational measures that ensure and show how an organisation is complying with the principles, for example through its internal data protection policies and procedures, internal audits of processing activities and staff training, appointing a data protection officer where appropriate, adopting the principles of data protection by design, which means promoting data protection at the earliest stages of a project or product, and data protection by default, which means embedding data protection into the heart of an organisation's activities. Example measures could be conducting data privacy impact assessments and data minimisation. Organisations can also demonstrate compliance by adhering to approved codes of conduct or certification schemes, and by documenting in writing all decisions and keeping up-to-date records on all data processing activities, including keeping data inventories and carrying out data mapping exercises. The documentation requirements for organisations with less than 250 employees will be limited to certain types of processing activities. Accountability is not a new concept under data protection law. Currently, organisations do notify their processing activities to the DPA. This will no longer be a requirement under the GDPR, but the information will need to be recorded and maintained internally in case it is requested. If you'd like to find out more about getting ready for GDPR, check out our website at www.kempitlaw.com.